Good afternoon, everybody. Welcome to another episode of your Wednesday weekly webinar with the Property Law Alliance. The reason I'm speaking like this is because it feels like we're living a little bit like in the Wild West these days in South Africa with everything that's going on in the country. So it's like, let me just pay my respects to it. How are you doing, Silma?
I am good, especially since I'm, in the west of Joburg. So on point. I am a Western girl, and I am very good. Thank you, sir. I won't try the accent, though. I can do my best Pretoria Afrikaans accent, but other than that, I have nothing for you.
Well, it's great to have you with us, Silma. Bruno, what say you, sir?
I wonder if you can keep this up for the whole episode.
Not a chance. Not a chance.
I'm good, Chris.
It's good to have you all with us today, Bruno, Silna, and the viewers. It's always lovely and a pleasure to have you with us on a Wednesday. We have quite a jam-packed session for you today, and I'm going to get straight into it. And this is a question that was asked by a gentleman by the name of Bizin Mutlake. And the question was, he's purchasing a flat, and he noticed that the lounge area in this flat is partitioned, and it's petitioned to make 2 extra rooms. He wants to know if this is legal, and if so, what sort of consent should he seek from the owner? So I'm not sure if that was asked properly, but that was the question. And I'm going to just pose it quickly to Bruno. Sure. It's around partitioning of a flat and to make 2 extra rooms, and he wants to know if this is legal.
Sure. All right. So the first thing we need to identify is what type of property this is, right? So use of the word flat, unfortunately, doesn't really give us a lot of information. Because you could have a flat sitting on a freestanding property, or a flat typically you'd find as a sectional title unit. So we're not, so we can't be 100% sure which one it is. So we'd kind of have to look at both. Typically with sectional, you don't. Sorry, apologies. Typically with sectional title units, you don't really deal with subdivisions, divisions at all, right? It's already a sectional title. It's already been registered as a sectional title. So you cannot further divide it up. From a rental perspective, though, it's a different story. So you can't officially go and divide it and register it somewhere. Unless obviously the body corporates have a different way of looking at the different divisions and things like that, but that typically wouldn't happen. So it then becomes a question of whether it's lawful and permissible to put that many people inside a unit. And look, what you sometimes find is the body corporates deal with situations like that. So they deal with occupancy, how many people are allowed, how many families. And what you do find is obviously with sectional schemes, you're supposed to have one family per dwelling. But you do find very often that body corporates sometimes do actually allow to have 2 families in a dwelling, depending on the size of the dwelling. And if the person's buying this property, that is something that they'd want to make sure of with the body corporate. It isn't something that commonly happens because flats that are already part of a sectional title unit, you find are typically small. So they're 1 bedroom, 2 bedroom. So you wouldn't very easily fit more than 1 family in it. But it is possible to rent it out to multiple people. So you often find that students live there simultaneously. They're not necessarily related or form part of 1 family, but they live there and they share a flat. Then if it's a freestanding property, that's very different because now it's a structure on a freestanding property, and we start looking at the questions of dividing up this property. If it's simply a wall through the flat, it can be done, but then it is going to require building plans that need to be submitted. And because now you're changing the density of this property, you are going to need to seek council approval because typically council would allow, depending on the area. So what we're actually finding is when you're looking at Pretoria, you're looking at Joburg, and when you're looking at Mogale City, for example, there's different requirements that the municipalities allow for. So in some areas, for instance, you allowed one main house with one extra dwelling. In other areas, they actually allow 2 extra dwellings if they give you consent, but they're very willing to give consent. So every area is different. Or rather, municipality is different. So it is possible to actually divide up structures into different, to allow more families to stay there. But then obviously you need to comply with the specific regulations. Doesn't really have much to do with the owner of the property in as much as it has to do with council. So you would have to undertake due diligence, make sure that the municipality is amenable to that. There are ways of figuring that out. And if they are, you actually just apply for rezoning or consent. And upon receiving either consent or rezoning, depending on how many people, extra units you want in there, you're good. You should be good to go.
Thanks, Bruno. I was on mute and I was speaking.
It happens to everyone.
It's to the best. Cowboy. To the best cowboys.
So now, please, can you give us your opinion on this particular matter as well?
Well, actually, I don't have too much to add. I concur with my learned brother. I think, Bruno, I think you wrapped it up perfectly. So I can't really add too much without boring our viewers by repeating exactly what you said. So ends my concurring with you. And the only thing I think that is important that I do want to echo, you've mentioned that, people use the term subdividing or partitioning very liberally. And if partitioning means there's a curtain and people are actually just overcrowding, I would definitely be very concerned. And also, just as a little off-topic hint, if you are viewing a property and you have partitioning in the form of curtain, blanket, boxes, with multiple families living in one place, I would be quite reluctant to buy without having a undertaking from the owner and the seller that the place will be vacant. And a little tip of advice, if you buy a property and you see there are risks of squatters, as squatters do, of squatters in the place, make sure that your offer to purchase specifically stipulates that you will not take transfer until the moment that the property is vacant. Don't rely on your vacant occupation on transfer clause, because if transfer takes place, even if the seller has to pay for the eviction, only the purchaser, the current actual owner of the registration, will have the locus standi to do that eviction. So I'm sorry that I'm jumping from a question about partitioning to eviction, but I suppose, you know, if you're a hammer, you will see most problems as nails. If you're an eviction lawyer, you will see every partitioning as a squatter. And I know that's unfair and not true in every circumstance, but as a purchaser, just be aware that you might end up having to do an eviction. And obviously, as a landlord, I see that more and more people are trying to rent out as much as possible of their space. Be very careful. Overcrowding is usually a very big problem. Currently, I don't know how to break this to you. It's only been a year, so maybe some people haven't gotten the news, but we're in the middle of a global pandemic, and overcrowding and a bunch of people together might not be ideal for virus control. I'm no virologist. How do you pronounce that? See, I said Afrikaans, ne? Viroloog.
That'll do it.
So, that will do it. But yeah, so just be careful of that. But other than that, that is how long I can concur, Bruno.
Nice, well done.
Unless you were buying a gym, because if you were buying a gym, you would want squatters in there, I'm assuming. That's a little bit of a gym joke for you.
I get my gym joke because I just noticed I have basically all my gym equipment very much showing on my camera today.
Okay, let's move on to the next question, and this question has a lot to it. So I'm going to pose it to you now, and it's posed by a gentleman or a person by the name of Christian Holly Smith, and they want to know where they can find information about using an installment sale to purchase a house, and they want to know what the process entails. And Christian wants to do some research before approaching a conveyancer on this. So please, can we assist Christian in this? And I'm going to direct this question to you, Silna. What's your views on this?
Okay, I'm going to break him down. Bruno, you're going to have to make notes here on what I'm leaving out, because I think there was so much that we should discuss about installment sale agreements, but I'm going to bore our viewers with a bit of a law of contract lesson. So I had the joyful privilege of doing law of contract at the University of Pretoria under the watchful eye of Professor Brzeski-Kuszka, which, to be honest, I think is one of the best law of contract lecturers in the country. I have the world's respect for her. So in honor of Prof. Brzeski-Kuszka, I will elaborate on the law of contract. I will bore you now, so get your popcorn and try to stay awake. The thing is, I very often see that people read something about a contract somewhere and they want that contract. They don't know what it means to have a specific contract. So, an agreement, any agreement, provided that it's not against good morals, so it's not contra boni mores, is a valid enforceable contract. Chris, for instance, if you and I make a deal for me to buy your hat, a verbal agreement, it's a validly enforceable agreement. I will have to perform in a way, for instance, pay you money for it, or, you know, wash your car, whatever the situation is. And you will then have to perform in the form of giving me that. Any agreement is a valid, enforceable agreement, even if it doesn't have a specific name. A contract doesn't need a name to be enforceable. It can be a memorandum of agreement. It can be agreement. It can be contract. It can be terms of engagement. It could be anything. It doesn't have to have a name to be enforceable. But once it wants to be a specific contract, for instance, a lease agreement, a deed of sale, an installment sale agreement, whatever, employment contract, the moment you want it to be something specific, there is something that is called essentialia. Essentialia is the Latin term for the specific terms of a contract that will make a general contract a specific type of contract. So again, allow me to be myself and use lease agreements as the example of this. So in terms of a lease agreement, the essentialia of a lease agreement is that the landlord must give the tenant undisturbed use and enjoyment of the premises. The contract must be temporary, and then the tenant must perform in terms of the contract in the sense of paying for or giving something in return to get the use and enjoyment of the premises. If those terms aren't in the contract, it's not an invalid agreement. It is not a lease agreement. So for instance, if you have an agreement that somebody can use your property and stay there for the rest of their life, it could be valid. Even if they're paying, it could be valid, but it's not a lease agreement because it doesn't comply with the terms. Now, why is this relevant? The moment you have the essentialia to make a contract a specific kind of contract, there are further things flowing from the essentialia called incidentalia. So your incidentalia is a natural flow from essentialia, even if it's not drafted into the contract. See, I told you I'm going to bore you. I hope your popcorn's ready. Why this is relevant is if you want something, for instance, an installment sale agreement, because you've heard it somewhere on a webinar or you read something, it looked cool. Now you want an installment sale agreement or a term that less pleasant is people call it an ALA. Now, I'm sorry, but where ALA comes from is the Alienation of Land Act. It's not a thing. It's not a kind of contract. It's an act. It's like saying, I want a pie contract. Like, huh? That's a lease agreement. What are you talking about? So with all due respect to the ALA people, appreciate just quickly that that's a specific piece of legislation you're referring to. To buy a property, in terms of the in terms of the Alienation of Land Act, in terms of that particular type of contract that the Act refers to, has very specific requirements and regulations. More often than not, this contract might not be the right thing for you. Both parties will have to be VAT registered. Both parties, if either one of the parties is a juristic entity, you can't use an installment sale agreement in the context of the Alienation of Land Act. However, there are contracts and options, a list as long as my arm, and like I've said in the past, I have pretty long limbs. So it's really a long list of potential contracts you can do. For instance, if I want to buy Bruno's property, but I don't want to I don't want to do an installment sale agreement because I want to buy it in the name of my company or trust or whatever the case might be. It's not going to be in terms of the Alienation of Land Act. It does, however, have to comply with the Deeds Registry Act. And that act does allow you to pay the purchase price by way of installments. So I can pay Bruno for 10 years in installments to buy the property. I can deal with the occupational rent separately. I can deal with the functioning of the transaction separately, and then transfer on payment of the full purchase price. On the other hand, if I want transfer now, but I'm going to pay it off in installments and the Alienation of Land Act installment sale agreement isn't going to work because I'm a juristic entity or whatever the case might be, then we're going to register the property, and then we're going to register a Kustensbrief, that's a Dutch law term, Kustensbrief in favor of Bruno, which is very similar to a bond. So as long as I pay the installments, it's cool, but the moment I stop paying, you can take the property back because I'm using it as security. So the point I'm trying to make is, it's not a one type of contract. There isn't just one way of doing an installment sale. And very often, the installment sale, the simple term installment sale, could be the very thing that makes your conveyancer or the attorney or whatever believe that it can't work in your particular case. So what I'm trying to say is not even almost trying to answer the question here, but I'll leave the answer to the actual question to Bruno. But I'm doing a nice little backdrop for you, Bruno. If you want to buy a property and you do not have the cash to pay the full purchase price at once, if you're not able to get a bond, if you don't want to get a bond, if the seller is able and willing to allow you to pay off in installments, there are multiple contracts to your disposal which you can use. So don't get stuck on a name ever. I often see in property context that people want a joint venture agreement. That's more so like a term, né? JV and ALA are the two things that I hear, and then I'm like, oh, giffy. Somebody was on a very quick course, and I understand why the perception is there then that is the right answer for you, but it might not be. A joint venture agreement, for instance, has very specific rules and requirements. It could be the right thing for you, and so could an installment sale agreement in terms of the Alienation of Land Act. But appreciate the fact that a contract doesn't have to have a name, but when you want it to be something specific, even if it's not called a lease agreement, if you have the essentialia of a lease agreement, I don't care what's written on the top of the agreement. It is a lease agreement. It will be governed by the Rental Housing Act, and it will have the naturalia flowing from the essentialia as well as the incidentalia, and it's important to be aware of that. I didn't even almost answer the question. Bruno, you try. I got distracted on law of contract.
That was beautiful though. That was actually beautiful to get that foundation. Yeah, that foundation going. So Bruno, the question over to you now, based on the foundation that Solna has just laid for us.
She raises a very good point with respect to people's understanding of contract law, because I'm dealing now, for example, with a matter where we're obviously we deal a lot with SARS as well, like tax issues, because part of my practice also involves tax law, and for example, like the payment of transfer duty and capital gains, if the installment sale agreement is drafted in a specific way. And we often play around with different options of things that mimic a transaction, but if drafted properly aren't the same and cannot be considered the same. And for example, I mean, you could have an option agreement, what Solna mentioned, the Custings brief, which is still a sale agreement, but there's different implications to it. And installment sale agreements, there's a variety of different things that we play with, even like the registration of usufruct. So there's so what she's saying regarding contracts is so important, because what I typically find with clients is they come with a name or a label, and it's sometimes dangerous because depending on the speciality of the attorney or his knowledge on these type of affairs, they're going to give you what you're asking for, and that's not always what you want. So you need to be careful. And I typically tell my clients, figure out the commercials behind what you want to do, especially my investment clients. It's different if it's a litigation matter or whatever, because I mean, that's a completely different story. But if a guy comes to me with a commercial issue, give me the commercial facts, explain to me what you want your business to be, and we can take it from there. If you're going to buy land in installments and you're willing to do it, and you don't want to take the property up front, there's ways of doing that. And granted, it is important for people to understand what they're capable of, what can actually be done. So yes, I'm not saying don't forget the legal behind it. I'm just saying less emphasis, leave it to us to kind of fit what you need to do into the right categories, because that's what we do for a living. But now to just help the viewer, so installment sale agreements, they're exactly what they're supposed to be. What people understand them to be. It's an installment sale agreement. So you're buying property over a period of time in installments, right? And that's a given. So as long as people understand it's not overwhelmingly different to that, it's, it does carry that definition. Now, Alienation of Land Act, and this is what Solna was explaining. There's certain contracts where you can do enter into agreements between the parties, but as soon as we start being very specific, or rather, we need to be very specific in order to comply with legislation. Now, why do we need to comply with the Alienation of Land Act? So what Solna was mentioning, for example, is you can buy land in installments without the Alienation of Land Act applying. You can. So I've done it with certain commercial properties. There's certain times where where the Alienation of Land Act doesn't apply. What happens then? That means that the protections given by the Alienation of Land Act won't extend to the parties, right? So it doesn't necessarily make the contract void. It just means that you guys are completely bound to each other contractually. And if anything goes wrong, you're probably going to need to rely on the terms of the contract to try and get it sorted out. Alienation of Land Act, on the other hand, does have certain benefits. So if you can bring your contract within the confine of these benefits that are located or are found within this act, you've got protection. So for example, as a purchaser, you can go to the deeds office, you can force the registration of the contract. So the Alienation of Land or Alienation of Land Act, under these specific sections, speaks about the sale of land in installment and has very basic terms or conditions rather, but it's terms that apply automatically to the contract. or that should apply, minimum requirements as they were. So a seller has to register. If a purchaser demands. If the seller doesn't, the purchaser is entitled to register. Once it's registered at the deeds office, all you're doing is registering the contract at the deeds office. All this means is now the seller can't go and sell this behind your back to somebody else. So it's a level of protection that you wouldn't typically have in a contractual relationship on installments, because they could do it, you wouldn't even know that they're doing it, and you can go after the fact and sue them. But now there's a risk that there's a third party involved, and now you're trying to get a property back from a third party. If you actually fit the contract within the confines of the Alienation of Land Act, the property cannot register to anyone else, because it won't be able to go through the deeds office. So there's, so there's really cool things like that that apply to situations that fall within the confines of the Act. So basic things to consider is it's over a year. So that's the one thing that we need to remember. So it's over a year, and it's several installments. So we do need to be careful to make sure that because an installment sale agreement, for example, over 6 months, it is an installment sale agreement for all intents and purposes, but not within the confines of the Act. So you do need to be careful and make sure that we follow the letter of the Act to the T. But just to give you an example, I mean, the Act, I think this particular section of the Act or chapter of the Act extends from chapter, I think, section 4 to 25. So that's just how much information that we need to go through. And what Silna and I were discussing earlier is it might not be a bad idea to actually have one episode dedicated to this and kind of touch on each section, because so just to give you an interesting, there's a lot of a limitation of 5 years agreements in terms of the Act.
Is it me or is it your sound, Bruno? Sorry. Chris, can you hear him?
Sorry?
Yeah, I think your sound is a little bit broken.
Your sound is a little weird. It makes like little breaks. I just said that. I'm so glad we're recording this. That is a gift for somewhere. Somewhere somebody can use that as a gift. It's a pleasure.
Okay, well, Bruno sorts himself out. It sounds to me like if you're entering into a installment sale agreement and you don't have an expert or at least an attorney on your side, it's a bit of a gamble. And that reminds me of a song, Solna. It reminds me of a song.
Oh
You
my
gotta
goodness,
know when to hold them, know when to fold them.
And it's right on to, on point with our topic. Chris, you make a good point, and I think I can fill in a little there. I think what people don't necessarily understand about what attorneys do is, and advocates and lawyers in general, when it comes to contracts, I think very often the perception is we draft these contracts word by word by word by word. Some of them you do. For instance, I mean, the TPN leaseback lease, I've drafted every single word in that, obviously with other attorneys there as well. But most of the time, we don't do that. We have butterworths, forms, and precedents. And all these contracts, we work from precedents. And then people are like, but why don't you just give me the precedent? It can't possibly be that expensive. And my analogy is, why can't a doctor just send you like a blank script and you just write in whatever meds you want? As attorneys, we know which clauses to go where. We know how to use the precedent to best suit your needs. So if you just say, can I please have an installment sale agreement? Easy peasy, you can probably, get it from Butterworth directly, the precedent. But is that the right contract for you? Are the terms in the precedent all the terms that you need? Or are there some of them that you need to exclude? Do you need to add some? And so contract drafting is really, forgive my right brain, but it's an art, because you need to know exactly what works together and what works and what doesn't, and what's going to protect both parties. And obviously your client as far as you possibly are allowed within legal limitations. So never see the work that an attorney does simply as the words we put on paper. It's the stuff that happens in here to get the words on the paper that you're paying for. You're not paying for a secretary, you're paying for the concept behind the contract. Bruno, I didn't sing, Chris sang, and I then entertained the audience with a bunch of other boring things. But now that you are back, you can have the stage again.
No, it's fine. So I mean, I think we were wrapping up on it. But it was just giving that example of the 5-year limitation, for instance, which is something that we've debated, we've spoke about, we've looked for examples that we could actually take before court. I've debated with other experts, and so there is a level of knowledge that one needs to have regarding the terms of the act. But at the end of the day, the clients do need to look at it from a commercial perspective. Don't necessarily always try fit your commercials into something. Like, do what makes commercial sense, and then we can look at it and we can see whether it fits perfectly. Because I mean, take for example, a 5-year limitation. Even if there was a 5-year limitation to the installment to an installment sale agreement, there's workarounds. There's plenty of workarounds, because the reality is you can have balloon payments at the end where you apply for finance. I mean, that's typically the simplest. So you don't need to pay 10,000 Rand a month every month for the rest of your life, and that's pretty much how far it goes. You can have a balloon payment at the end. I've even had the Registrar of Deeds accept options, like almost options to renew or to extend, where we just set it out saying, look, if it gets to this period and for some reason the person's finances aren't in order, we set something up in order to allow consideration for an extension of the period of time. So there's a whole bunch of different ways of doing it. So focus on the commercials, get that 100% right. And then we'll have to obviously prepare something just to give you the fundamentals, because you do need to at least know the fundamentals. And once you understand the fundamentals, focus on the commercials. And then when we work together on it, we can structure it. And just to kind of touch on or echo what Silna was saying, it comes down to quality. I'm looking at a lot of the agreements that I work on now, and because I've been doing certain agreements for years and years and years, I will actually look at some templates that are out there and go, wow, okay, I cannot believe that this is actually what people are working off, or what I worked off the first time I ever did it. So as much as there's templates out there and some attorneys use templates, I think we are living in that area of specialization, 10,000 hour rule, where if you've done something for 10,000 hours, that template that's sitting on some website that goes, general practitioner, here you go. If you need to do this, here's a nice contract for it. We will look at this and go, it's a disaster. It's a problem. I've been to court 5 times on this very same agreement, and there's an issue with it. So I think people also just need to realize, to a certain degree, you get what you pay for. You want something and you don't think there's a risk, by all means. There's probably somebody out there that can do it for you relatively cheap that hasn't done it before. But if there is a risk, if it's a big transaction and you are worried that you stand to lose money, or there's occupiers there and it's going to take ages to evict, and it's happened, I've seen it a million times, where people come to me and they're like, oh, there's an issue with this transaction, would you assist? Eventually they back off because they don't want to pay money. They take transfer of the property, and then they come to me again, and unfortunately the realization dawns, had they acted sooner, they would have probably saved up to like 200,000-300,000 Rand just by maneuvering and positioning themselves correctly. So just be careful, guys. It is, this property investment does contain an element of like strategy to it. You need to know that. Exactly.
Bruno, I'm so glad you mentioned that, because from the viewer specifically said, before I go to a conveyancer, I'm all for conveyancers drafting, and honestly, when it comes to installment sale agreement, definitely have a conveyancer in the team as well. But have an eviction lawyer as well. I'll tell you why. The evictions that I've struggled with and that took the longest, comes from installment sale agreements. I'll tell you why. There are a bunch of requirements. There's constitutional case law that says that once you've paid a substantial amount of the purchase price, suddenly you can't just evict. You need to tender transfer. You need to do all sorts of fun things. And if the contract is not properly drafted with an eviction expert eye on it, knowing that if there's a problem and we need to evict this person, there are very specific things. Unless we can specifically quantify the rental, occupational rental portion in relation to the purchase price, unless we can show very specifically that if this contract goes south, we can evict. And remember, contracts are made for divorces. As long as everything goes well, you don't need a proper contract. You know, lekker. If things go south, you need to know that every single clause is there to protect you, because I've had clients, and it breaks my heart, where the installment sale agreement was done by a conveyancer perfectly in line with the Act, 100%. And I'll give it to them. But the conveyancer did not see the possibility of eviction. And it's a very scary place to be in. And those evictions, when I say take a long time, like in proper 2-3 years, because the underlying contract is now the problem, and you need to litigate on that before we can determine illegal occupation and then commence eviction. So please make sure that you use a team of attorneys. One attorney is cool, but our value lies in talking things through. Then even, I mean, as everybody knows, Bruno and I are in constant communication, and it's amazing. On the same topics, we tend to have the same opinions, but when you argue through, for instance, a specific contract, the way you would draft, I promise you, we won't have the same ideas, which is exactly what you said, Bruno. On yes, you have your templates and stuff, but how you apply it and what you do and how you draft is going to be different. So make sure that you have an eviction or at least a proper exit if needs be.
Absolutely, yeah.
No, that's great advice, Salna. And I think the one thing that I took out of this is that when you see an expert, what you're doing is you're seeing somebody who, first of all, can draft what you want. But you raise this, is that if something goes wrong, that person needs to know how to fix it. And that's what makes the person an expert in the field. So I think when you're doing these kind of contracts or these arrangements, it's always important, like we're saying, to have that expertise behind you, to have the muscle behind you, because at the end of the day, this is investment. This is something that you're putting your money toward. So you'd want the best advice out there. So guys, thank you so much. What an amazing session we've had today, in record time as well, 39 minutes. That feels good. Yeah. So thank you so much for that. And to the viewers there out here, please join us next week. Ask your questions in the group. And we'll be more than willing and glad to answer them and to pose them before our experts next week, Wednesday. Thank you so much, guys. Thank you, Salna. Thank you, Bruno. Goodbye.
Thank
Thanks,
you.
Chris.
Bye-bye. Bye.